day, everyone. I'm Hanoneshea Hendricks. I work for Legal Aid South Africa. I'm the National Legal Manager in Civil. And today I'm going to talk with Marlise, and we're going to talk a little bit about the Domestic Violence Amendment Act and what we can expect now when we go to courts.
Good morning, Hanoneshea. I'm Marlise Wooldridge. I'm a Civil Legal Practitioner at the Legal Aid Advice Line. And we hoped that this would be a very informative session for all those watching.
Yeah. So Marlise, one of the things that I know that the Act wants to combat is this issue of bystanderism, where in South Africa we seem to see that something goes wrong and then we don't do anything, especially when it comes to gender-based violence. So I know that there's something about mandatory reporting in the Act. And which says that some people must report. What do you know about that?
Indeed, Hanoneshea. The Domestic Violence Amendment Act, they make provision for mandatory reporting, which places an obligation on any adult person or a functionary, which includes educators, healthcare practitioners, or medical practitioners, to mandatory reporting when there's a reasonable suspicion that domestic violence is being committed against a child, a person with disabilities, or an older person.
Okay. So in terms of this mandatory reporting, when I hear you speaking, it sounds like first responders. So it's people that would see, a victim or a survivor of gender-based violence, or domestic violence, when they come and tell them something has happened. Does it also mean that, when you just see it happen, that you must report? When I walk in the street and I see it happens, I'm not a first responder, I'm just a person in the public. Must I report it?
It is mandatory to report when the victim or the person on the receiving end of gender-based violence is a child. That means any person under the age of 18, whether it is a person with disabilities or an elderly person.
Okay, so that is important to know, that even, when I just live in my community and I see a child, an elderly person and a disabled person experiencing domestic violence, I think it is happening, like you say, a reasonable suspicion, that I should report. I think that is important for the public to know, that it is mandatory that you report that when it comes to a child, an elderly person, and a disabled person. What about people that don't fall in that categories? Is there an obligation to report?
There is not an obligation to report. As we've mentioned, it's only in terms of free class of people. And I think also we need to inform the public that the reporting must take place either to a social worker or to the South African Police Services. The public can obtain information regarding social workers from the Department of Social Development, and then they will refer them to the nearest available social worker who can assist.
Okay, so it is also functionaries that the reporting must be. It must not be to your neighbor. We are not talking about gossiping. We are talking about intervention so that you can seek assistance for the person that is experiencing the abuse.
Indeed, that is correct.
Okay. I think it will go a long way in terms of addressing bystanderism, that sometimes people might have felt they see something happen, but it's not their place to intervene. And now the law makes provision for you to take a step to help somebody that you see are experiencing domestic violence. Yes, so, and then in terms of reporting, I do know that even if you're not part of the mandatory categories, or the categories in terms of which mandatory reporting is required, that you can report, but it does require that the person who is the survivor, who is experiencing the domestic violence, that person must then react to what you are reporting, meaning that person must confirm that it is happening and then initiate the charges, the complaint at the police. So it also, it tells me that the Act says that you can if you see it happening, but it's not mandatory, and that there's still an obligation on the person experiencing the abuse to act and complain and lodge or lay a charge at the police station.
Indeed. The Domestic Violence Act also makes provision for that any person who is in a close relationship with a victim of domestic violence, for example, if you are an aunt or uncle or a grandparent, so forth, that you can bring an application for a protection order on behalf of the victim or the person who is being subjected to domestic violence.
Okay, so yeah, so that means it doesn't have to be, sometimes women don't find the strength to act through on what has happened to them, meaning lay the charge, lay the complaint. So you are saying that someone else can do it and help them to do it?
Yes, indeed, they can support them, and then also children are able to apply for protection orders without parental consent, and it is obligatory for the clerk of court and the presiding officers to consider the application on the child's behalf.
Okay. So I know that, the Act has always made provision for interim protection orders to be granted. Interim meaning you go to the court today, you are applying for a protection order in terms of the Domestic Violence Act, but in terms of the legal process, the other party needs to have a day on which they come to court, to defend or oppose what is happening. But in that period, the court can give an interim order of protection. So, the Act has always provided for this interim order. But now, the Act also talks about a safety and monitoring notice that can be given to the court.
Indeed. The applicant in a domestic violence application can either ask the court at the same time when they are applying for an interim protection order to issue a safety monitoring notice, or at any time between the interim protection order and whether the order is made final, and also even after a final order has been done. Now, it's important to note that the safety monitoring notice, it gives an obligation to the South African Police Service to either check in electronically or in person with the complainant or the applicant in domestic violence matters. The purpose of this is when the two parties still share a residence and there is a fear of harm that may come to the applicant, then there is an obligation on the SAPS to check in regularly and to also provide reports to the court if required to do so.
That is really progressive also in my view, because it means that the police must check in if, the survivor is still okay. Is that basically what it means?
Yes, that is what it does. It is just an additional protection that is afforded to the applicants and to the victims, that if indeed anything happens, that the SAPS will be available and that they can be approached. One of the also extensions is the SAPS can insist on speaking to the applicant privately without the presence of the complainant or the alleged abuser. So it allows us to be proactive in terms of protecting victims of domestic violence rather than being reactive.
Yeah, that's great. Now, I know, the Domestic Violence Act has not been implemented fully yet, and that, it provides for an electronic means of application, of making this application for the protection order. It means that I potentially do not have to leave my house, and that if I have access to electronic devices and equipment, that I can make this application without needing to leave the place where I'm safe at.
It indeed makes the relief and protection more accessible for all members of the public. we all know that in far outlying areas it would be difficult to travel to the nearest magistrate's court to apply for it. And then this will make it more convenient, safer, and I believe a more expedient manner in applying for protection orders.
It will take away that barrier that I actually have to travel somewhere to apply for this protection. I have to get into a taxi, if it's a taxi, a car, I have to walk outside my house. Some people live in villages, like you say, and they have to travel far just to access a police station or a court. And so this will really increase access in terms of placing that protection or the application of that protection in their own homes.
It is indeed making access to justice more accessible to all persons who are residing in South Africa, and I believe it will also play a big role in curbing the occurrence of domestic violence in future.
Yes. So we just need to say that at the moment the electronic systems is not available at the Department of Justice yet. They are upgrading their systems to make provision for this electronic means of application. But when it is upgraded and available, there will be communication to all members of the public to communicate that you can now apply online for a protection order. And this is not only in terms of domestic violence, it will also be in terms of the Harassment Act. So it would be great in terms of the Harassment Act. It also includes relationships that does not necessarily fall under domestic relationships. But it also deals with where people are harassed and needs protection. So thank you, Marlise, for the discussion on domestic violence. I hope that what we've discussed today helped somebody, gave somebody some information they didn't have, and that if you need to access any of the protections that we've spoken about, if you need some further information, if there's something that you need clarity on, please feel free to call our Legal Aid Advice Line on 0800 110 110. We also have a Please Call Me number, which means that you can send a Please Call Me to the following cell phone number, and then the Legal Aid Advice Line will call you back. So, Marlise that's been talking to me today works at the Legal Aid Advice Line, and if you call that advice line, you'll speak to somebody as experienced in the law as Marlise. So do not hesitate to call about anything, not only domestic violence that we spoke about today, but any other legal advice that you might need.
Please note that our advice line hours are Mondays to Fridays between 7 a.m. and 5 p.m. and all of our agents look forward to assisting the public wherever needed.